Welcome, ladies and gentlemen. This program is Not on My Watch, a university's guide to avoid being a Sports Center breaking news headline, the anatomy of a compliance program. The length of this program should be about 50 minutes. I'm Bob Wallace. I am one of your hosts. I am a former executive and general counsel for the St. Louis Rams, Philadelphia Eagles, and St. Louis, Arizona Cardinals. I head the Thompson & Coburn's Sports Law Practice Group here in St. Louis. I am a past president and current director emeritus of the Sports Lawyers Association. And my practice includes advising executives, athletic directors, and coaches on their contracts, compliance, and other related matters. Joining me here is Jan Miller. Jan?
Thanks, Bob. Good afternoon, everyone. Thanks for joining us today. I hope you'll find this presentation informative. As Bob mentioned, I'm a partner here also at Thompson Coburn. I'm currently head of Thompson Coburn's Corporate Compliance, Investigation, and Defense Practice Group. Prior to joining Thompson Coburn, I've been here about 8 years now. Prior to that, I spent about 17 years as a federal prosecutor, both as an assistant U.S. attorney in the District of Maryland for about 13 years, and then I served for about 4 years as the United States Attorney for the Central District of Illinois. Obviously, in those positions, gained a lot of experience regarding investigations, regulations, statutes, prosecutions of all various types and natures. So as a result, part of my practice since I've come to Thompson Coburn, and particularly as head of our corporate compliance and investigation group, is to advise various clients that we have on compliance issues, conducting internal investigations for clients when appropriate, and handling the various types of litigation that can arise out of compliance matters.
This presentation and this program is not a defense presentation. This is not an infraction defense presentation. Once you have been charged with a violation, you need a defense strategy. And of course, we or many others can assist you with that defense presentation. This presentation is about positioning your athletic program to avoid problems. It's about having procedures and protocols to react to those problems. And it's about also reacting to the problems in an appropriate manner in order to get the best options. We'll talk about suggestions on who needs to be involved, how to react, and when reacting, the timeliness is often critical element in the punishment that is actually fashioned. So who needs to hear this presentation? We think this presentation is meant for the chancellor or the president, because the buck really stops with that person. He's ultimately responsible for what goes on in that campus. Many times the president has a trusted advisor, whether it's the chief financial officer, the chief administrative officer, the general counsel. Isolating the president from hearing bad information is not a defense. Plausible deniability is not a defense. Often, as we saw in Penn State, the board needs to be informed. They have a responsibility. They have also a fiduciary responsibility. So board members need to know what's going on. The athletic director, you are the gatekeeper, so know what's going on within your gates. The compliance director, it's not easy being the chief of police, but it is vitally important. And the compliance staff, community policing, which is being involved, familiar, and friendly, is fine, but ultimately you have a job. As we look over the past several years, and really since Penn State, which really kind of began the whole sort of look at compliance, there have been a lot of painful lessons that we've learned. And if you look at Penn State recently, they just settled their lawsuit for another $67 million. They've spent over $100 million on this, on not having a proper compliance process in place. You have Rutgers, you have Miami, just to name a few. These are the type of problems that you can be hit with, and it can cause your institution great problems.
So oftentimes when we're dealing with any business or company regarding putting in place a compliance program, we get a very basic question from the client, and that is, why do we need to do this? It's obviously, we recognize, time-consuming. There is some upfront cost to it. Specifically as to universities and colleges, this is relatively new. Compliance programs have been around for a long time in a lot of other industries, and we'll talk about that in a moment. But there has been a change in the public as far as the perception of universities, their roles in the community, and frankly, the information that's available to everybody these days. You know, in days past, decades past, universities, particularly ones with popular athletic programs, were often given a lot of latitude to police themselves, and frankly, if there were infractions, they were not necessarily reported. It was simply a much more closed environment, less open to scrutiny. What's happened over the years is that universities now are coming under the same sort of scrutiny that other businesses and other industries have endured really for years. So what's going on in the university setting might seem new and is, I'm sure, of some concern to folks in the university setting. It's not new from a business setting. It's something that in a lot of different industries has been around for quite a long time and is now coming to play in the university setting. And part of the reason for that is, rightly or wrongly, universities, even universities that get no public funding, that are private universities, are viewed as responsible for and answerable to the greater community. You know, when you have an institution such as a university where a local town, for example, gets its identity from, that's obviously a major benefit to the university for recruiting and for all sorts of things. But there are responsibilities and there's scrutiny that comes along with that. And that's one of the things that's adding into the new environment that we're finding ourselves in. Obviously, also what's going on these days, not just in this arena, but in all sorts of arena politics and what have you, is the change in media and the availability of information from all sorts of outlets. I mean, the bottom line is, with social media, with the 24-hour news cycle, it's virtually impossible for anything to stay under the radar. You have to assume that whatever is going on at your school is going to be able to pass the front page test. That is, how's this going to look on the front page of the newspaper tomorrow, or the front page of your favorite website, because you've got to assume that information is going to be out there. The result of all this, then, is that if you don't take a proactive approach, if you don't try to avoid problems to begin with and have something in place, you're really asking for tremendous trouble down the line. Now, as I've mentioned a couple times already, this is not a new phenomenon in the U.S. It might be a new phenomenon for university and colleges, but there are places we can go to, that you can go to, for the playbook here. In particular, businesses that deal with the federal government have had to deal with this type of scrutiny for a long, long time. It's part of their business practices. For example, government contractors, any company that does contracts with the government, either on a limited basis or as a major part of their business, is used to having audits, having the government come in and look at them, being under scrutiny. Healthcare, anybody in the healthcare industry, I mean, you can't really swing a dead cat without hitting a healthcare regulation. And so anybody in the healthcare industry is used to and has had to deal with being under this type of scrutiny, and therefore dealing with having a proactive compliance program. And what they have found, and what we've seen in working with our clients in these particular types of industries, government contracting, healthcare, is that having a compliance program in place, while there are some initial upfront short-term costs, it is vital to the continued success of these types of businesses. It's vital to monitor compliance, because if you don't find small problems, they will turn into large problems. It's vital to have a safe environment so that anyone within your organization can report potential problems, because again, that allows you to nip things in the bud before they get out of hand. And it's very, very important to take proactive steps when a problem is uncovered, and problems will be uncovered. No system is perfect. So what we're recommending today is, one of the things to do is to use the compliance programs and the policies and the procedures that have been used for decades in these other industries and fashion them to your particular needs. So you're not starting with a blank slate here.
I think it's also important to mention, Jan, that because of so much of the, as you mentioned, with the media attention to this, but you also are getting congressional attention as well with the concussions, with the O'Bannon case and use of your likeness. There's all sorts of people that have interest in getting on front pages, and they're looking at your programs, and that's a way for them to draw attention to some issue that they might find very important.
Yeah, that's absolutely true.
What we're going to do here is we're going to sort of give you a sample fact pattern. Not that we're going to do this as a case study. We're not going to say, well, what would you do here? But what we are going to use this is to help you and want you to keep this in the back of your mind as we go through this program, to listen and listen to the presentation, to put in sort of some of the things that we're talking about in the context of what we're talking about when we talk about specific contract language or policy language, and then hopefully this will help you in coming up with some questions if you have them. So here's the fact pattern that we're going to talk about. It has just come out in Sport Magazine in its November edition, a story detailing a long list of embarrassing NCAA violations and perhaps illegal acts that have occurred on State University campus involving its student athletes, in particular its football and men's basketball program, and those two respective programs. The alleged activities include a performance-based money bonus system administered by the school boosters, an academic fraud scheme involving test-taking and paper writing, a make-believe summer jobs program, and numerous other recruiting irregularities or infractions by both programs. It is unclear whether the football coach, who has been at the school for 20 years and has been very successful, including a BCS national championship 4 years ago, is or was aware of these activities in the football program. The basketball coach came to State University just 4 years ago, also after a successful run at a smaller institution, when the previous State University coach was relieved of his duties, also after a long run at State University, by the new athletic director who came to the State University 5 years ago. Since the basketball coach's arrival, that program has also risen in popularity and participated in the men's basketball tournament the last 3 years. It is unclear if the head men's basketball coach or any member of his or the football coach's staff was aware or should have been aware of some of these alleged violations. There is also no definitive evidence of when anyone in the athletic department became aware of these problems. Consequently, you are presented with these impending revelations and faced with some tough days and decisions. Of course, your primary concern is to comply with all relevant laws and NCAA rules and to fulfill the university's greater mission.
So the question we're going to, or the questions we're going to deal with today are, okay, this problem has now come up. What could State University have done to avoid or minimize this damage? What should have been in place? Because as Bob said, we're not necessarily here to talk about details in a specific problem, and once the headlines start coming up, it's really too late to close the barn door at that point. So what could they have done to have a proactive program in place before the problem arises? One of the themes you're going to keep hearing as we go on for the next 40 minutes or so is that part of what you have to keep an eye on when you design a compliance program and when you enforce it is the perception, the outside perception of that program. And I don't mean that in a pejorative sense. What I mean is this: you can't avoid all questions. You are going to be questioned about how things were done when a problem arises. But what you want to do is you want to take away as much ammunition from the Monday morning quarterbacks as you can. You want to have a system in place that, from an outside objective point of view, indicates, shows that the university has placed a high priority on compliance and that things have been dealt with in an appropriate fashion. And it all, as we say up here, it all begins with a process, and we're going to walk through these 5 steps now. We have setting up a proper organizational structure, hiring the right compliance director and providing the necessary tools, reviewing all the athletic contracts, establishing a training program, and then what to do when you have a problem arise. So let's start going through these steps now and see what you can do to try to avoid some of these problems.
So as we said, step number 1 is setting up your proper organizational structure. Who reports to whom? Where does the compliance department reside? Is it with a specific sport? Is it in athletics? Does it reside in the general counsel's office? In setting up that organizational structure, this might be the most single important decision you make in setting up an effective compliance program. As we look at what we're kind of terming as a problematic organizational structure, you look at it and it's very linear at top, starts with the university, the institution, goes to the board of directors, the chair of the board, the president. But then if you look over to it, you see the head coach is on a vertical line with the athletic director and the general counsel. The head coach may be reporting to the president or general counsel, or he may have a direct line to it. This can cause a little problem. And also, with the director of compliance reporting to the athletic director, that also can present a independence problem. I hate to say this because there may be some athletic directors on the phone or listening to this presentation, but athletic directors are also judged by the success of their athletic program, whether it's winning or financial, and they have a vested interest in keeping the problems at a minimum. Again, as Jan said earlier, the perception of your problem, of your program, must be considered. It will be looked at, and if you have people who have vested interest in the compliance area or watching the program, it sort of looks like the fox is guarding the hen house. So we look at what we...
Go back to that last one for a minute, Bob, before we move on. Now, this is the one that in our sample example, this was the setup for the football coach for State University, right?
Yes.
And let me ask you something. You've got here over on the left under head coach, you've got director of compliance under the athletic director, and you explained why that's not necessarily a good idea. But you also have sports compliance over there on the left under head coach. And let me ask you this, because this is a question that comes up sometimes. Why not have a sports compliance program within the sport itself? I mean, the argument would be, well, if you have a compliance person sort of embedded in the program, they're going to have a better opportunity to see problems quickly, to understand how the program works. Isn't that going to give you better insight into what's going on?
It could provide additional insight, but it may not be worth the lack of independence that can give rise to. This is human nature, and if I'm around people and I begin to like them and I begin to have a sort of become invested in what they're trying to achieve, then I may not be able to look at them with the critical eye that I need to have. So I think that it's nice to be embedded. You may learn something, but I don't think the risk of having that person not have that independence is worth what you need. And
in your experience, have you seen programs like this set up where you've got compliance officers embedded in or reporting directly to a head coach? Or
Yes, I have, and and it has been at some of the bigger programs, which a lot of times have very powerful, very successful coaches, which just gives more evidence of how hard that is to have the compliance director be that independent. So again, we like this the second structure a little bit better. If you look, it's still very linear at the top, but the athletic director supervises the head coaches, and compliance is over under the general counsel's office or the CFOs, but it's out of athletics. As I said earlier, the athletic director has some interest in the success of the athletic program, so he's also trying to avoid as many problems as possible. We want our compliance and our governance to be independent and have autonomy. And also because so much of this, of compliance with various regulations, rules, and federal and state laws. One of the things that happened in Penn State is that they didn't comply with laws, and that became obviously very, very problematic for them. And it would be helpful if your compliance director had the resources of the general counsel's office to make his recommendations and his findings. So the next question is, and then we talk about this, and it says, how high up does the responsibility go? And if you look at Article 2.21 of the NCAA Constitution and bylaws, it says the institution's president or chancellor is responsible for the administration of all aspects of the athletic department. as we said earlier, plausible deniability, in fact, I didn't know, is not a defense. If you look at what a typical university manual, it says the information concerning violations will be forwarded to the Director of Athletic Compliance, who will examine the situation and communicate with the Director of Athletics and the Executive Vice President and Chief Financial Officer. What I think that particular language lacks is the responsibility to inform the President or the Chancellor of what those findings are. As I said, and as this Article 2.21 says, that responsibility goes directly to the President and Chancellor. So it's very important that the information is going to the highest levels of a university.
And with that in mind, Bob, does that link in at all to the other preferred structure that you had a minute ago with the compliance officer reporting to the general counsel as opposed to through the athletic director?
Yes, I think that the general counsel, that there's a greater chance, and hopefully that the general counsel will have that sense of independence and will give the proper information as the lawyer for the university to the president and the board of directors.
So you have a structure in place. Hopefully you have a structure in place where you've got an independent, truly independent compliance department reporting through the general counsel up through to the president. Next step, obviously, is you have to hire the right compliance director and provide him or her with the necessary tools. And what do we mean by the right compliance director? Well, it might go without saying, but I'm going to say it anyway. The most important thing here, especially if you have a major institution like a university or a college, you have to have somebody with compliance experience. Obviously, experience in the athletic field is a bonus. But from where I sit, if I've got a choice between choosing someone who has extensive compliance experience in a different setting, healthcare or government contracts or what have you, if I'm considering that person as my compliance director as opposed to someone without any compliance experience but experiencing the athletic department, you're much better off taking the person with the extensive compliance experience for a variety of reasons. As Bob said, it's not easy being the chief of police, and the experience that one gains through being in a position where you have to, on the one hand, be the police officer for the institution, the company, whatever, and on the other hand, figuring out how to deal with powerful people, influential people within the organization. It's a very important tool to have. And somebody who has been running a compliance program for a large hospital or a large corporation is used to that type of dynamic. So it's not just knowing the ins and outs of particular statutes or regulations, but it's also understanding exactly what the job is and what it takes. And, you know, sometimes these types of positions I've seen where they're basically viewed as a parking place for a long time well-liked employee. Well, we got this guy, everybody likes him, he gets along with everybody, people will talk to him, he's not going to ruffle any feathers, he's only going to be here for a few more years, let's make him head of compliance. That's a relatively, unfortunately, common thing that we see. That's exactly the wrong way to go. Okay, this is not a parking place for a well-liked employee to finish out his or her time. We got a question at one point early on as to what has changed. Why has, we talked about how the environment has changed here, and one question came up, why has this changed? You know, the NCAA compliance requirements have been in place for years and years and years, and that's absolutely true. What's changed is the environment within which you are working. What has changed is the amount of people, the number of people, the number of agencies, the oversight that comes in through, as Bob said, political arms. It's the stakes. It's the atmosphere in which you're working. That's what's changed, not the basic rules that you're supposed to be abiding by. And therefore, that links into making sure that you have a compliance director who's going to stand up to the scrutiny of all these outdoor organizations. You know, there's a reason why publicly traded corporations have independent outside auditors. Obviously, Sarbanes-Oxley requires it, but they've had it even before Sarbanes-Oxley, and that's because you need somebody with the experience, but with the independence outside to make the hard calls and to tell the powerful people when they're doing something wrong. So on the third point here, you should think about bringing someone in from the outside. Obviously, there is a benefit to having a compliance director who's familiar with the department, familiar with the personalities, familiar with the structure. On the other hand, there is a tremendous benefit to having someone coming in from the outside with a fresh set of eyes. You know, there's a lot of inertia that takes over with any organization, and it's very difficult to edit your own work, if you will. So having somebody come up through the ranks and try to take an objective look at your compliance program and what needs to be changed and that sort of thing, very difficult to have that done in a complete fashion from someone who's completely homegrown. I think there are a lot of benefits to looking outside of your normal circles to find a compliance director.
Jan, let me ask you a question. Does your compliance director have to be an attorney?
No. Compliance director does not have to be an attorney. There are benefits if the compliance director is an attorney. We can talk about that a little later regarding attorney-client privilege. So there are benefits that come with that, but it's actually, in my experience, it's relatively uncommon. Most of the compliance directors I see are not licensed attorneys, and that's not a requirement. Once you've selected your compliance director, you have to make sure that he or she has the tools that they need to do the job. Again, some of these might go without saying, but it's surprising where I've seen lots of situations where they're not in place. The compliance director needs to have the authority to draft effective university-wide compliance policies and procedures. You know, ideally, you have a compliance director. We're not talking about somebody who's just compliance for sports. You're talking about somebody who's the compliance director for the entire university. And another question that we get sometimes is, well, could this be a part-time job? The answer to that is no. If you're running a major university, a major company, a major organization of any sort, you cannot have a part-time compliance director. I will tell you that the biggest problems that I've seen dealing with clients in other areas, like, for example, healthcare, a problem will arise. We'll get called in to look at a particular billing problem or what have you, and invariably in the situations where the compliance director is, an other duties assigned kind of position, it's a mess. It's really a mess. Records are not there. The policies are not kept up. No training has been conducted. It's just a horrible, horrible mess. And so it really needs to be somebody who has the authority and has the time to do it right. You have to give the compliance director the authority to set up an anonymous internal mechanism through which anyone, student athletes, regular students, coaches, boosters, whoever, can report potential violations. Now, oftentimes we'll get a question, well, aren't you asking for trouble there? The answer is, well, I guess you could look at it that way, but you want to know where the problems are. Again, the goal of this whole thing is to find out where the holes are, find out where the problems are early, so you can take care of them early before they blossom into a major event. And you need to give the compliance director the authority to hire outside counsel when necessary. It's not going to be necessary for every potential violation, but when things grow to the size or have the significance, the compliance director needs the authority to be able to hire outside counsel to come in and conduct an internal investigation. Again, remember that part of what you're going for here, and again, I mean this in a positive sense, is that the perception of your program when an outside governmental authority or whoever looks at it, it stands up to scrutiny. And having outside independent investigations run for serious matters is the norm in the compliance world. And if you're doing all of your internal investigations yourself with university people, that's going to be suspect when you have a real problem on your hands.
And I think it's also very important in the new NCAA rules. They've also one of the things they look at is whether your university has a culture of compliance. So you need to have systems in place so that you can point to, this is what we've done, this is how we've done it, these are the rules that we have in place. And it's very important as they're looking at your program and fashioning punishments. So I guess step 3 of this is that as you're sort of looking at your programs, you want to review all of your athletic contracts. And that starts with your head coaches, your athletic directors. You want to know what their list of duties and responsibilities are. You want to know who they're reporting to, who's reporting to who, where the lines of authority are. You want to know the disciplinary mechanisms that are in place, and you want to know what the termination clauses are. You want to make sure all of those are strong and all of those are in place. If you look at the athletic director's sample contract of an athletic director's contract, it says the athletic director further agrees to abide by and comply with the Constitution, bylaws, interpretations of the NCAA and the conference and the university rules and regulations, and that he shall report the same promptly to the chancellor or the president. So the athletic director has a responsibility to know the rules and to report when their violation happens. The athletic director is held accountable for supervision of departmental staff, including the head coaches and assistants, including the department and its staff, compliance with the university, conference, and NCAA rules and regulations. He's also held accountable for integration of the sport into the whole spectrum of academic life to complement the university and its mission. In the number of contracts that I've reviewed, both in athletic directors and in head coaches, I can't emphasize how important it is to make clear that there is a responsibility for the athletic department to be integrated into the academic life and to complement the university and its mission. We have to remember that we're talking about educational institutions, and that is of paramount importance. And finally, the athletic director is responsible for complying fully with and helping with investigations by the university, the conference, the NCAA, and I would add with law enforcement officials if that happens to come into play. If you look at another sample contract, you look at like the head coach, and again, keep in mind the fact pattern that we talked about when we listed the head coach, and he has a similar compliance responsibility with the compliance responsibility as well. He must abide by and comply with the Constitution, bylaws, and interpretations of the NCAA, conference, and university rules. However, if you look, and let me go back to that one more. The list of his specific duties and responsibilities supplements and is not exclusive of the other general duties that may be assigned to him by the chancellor or his designee. And I'm not sure that this football coach, if you look at it and we go back to the earlier organizational chart, is he reporting to the athletic director or is he reporting to the chancellor? And it looks to me that he has a direct line to the chancellor in this situation.
And so just to be clear, some of these samples that we have in here, we want to make sure we're clear. Some of them you like the language in there, and some of them is problematic, like the one you just pointed out.
Like the one I pointed out. Yeah, so you look at the duties and responsibilities of many of these, and we're going to go to the next one is after this would be the basketball coach. They're very similar. I mean, there is a compliance with the Constitution, bylaws, and with the NCAA or the conference or the university. When we get to the basketball ones, I'll point out his is a little stronger. And again, if you're looking at these situations and you go back to our fact pattern, the football coach had been a long-time employee. He probably had a contract in place. The basketball coach was coming into the situation after a problem, so the athletic director or the university council, whoever drafted the contract, did a better job in setting out the responsibilities of the basketball coach. So let's go to and again, this is just an example of the control by the university for the football coach, and where they're asking for where he has an opportunity to make additional monies, or they're setting his goals, or all those things. Again, with this football coach, the chancellor, the athletic director, the faculty athletic, there are a lot of people involved in evaluating this coach, and I'm just not sure that it's clear who the football coach reports to. If you look at the next one, which is the basketball coach, again, as I said earlier, this is a concept of a coach coming into a situation that was a problem before. And in this, the language is very, very clear. Here, there's a specific section that says rules compliance, and it says the head coach agrees to fully and completely comply with the Constitution, bylaws, rules, regulations, policies, including self-imposed sanctions, procedures, and or other disciplinary action, including current self-imposed sanctions and standards of the university, the NCAA, and the conference, and any amendments thereto or interpretations thereof. The head coach further agrees to fully and completely comply with any and all decisions, sanctions, or other disciplinary actions established or issued from time to time by any and all interpretations of the NCAA rules and regulations, including without limitation those of the university's athletic department, the NCAA, or the conference. Also, here's some very, very strong language in the basketball coach's contract that I think is great language, where the head coach acknowledges and agrees that his compliance obligations include strict adherence to all of the governing rules relating to the conduct of the administration of the men's basketball program, including but not limited to those relating to the recruiting, and that he is responsible for compliance with the foregoing by all his assistant coaches and staff members, players, and by all other individuals under his direct or indirect supervision, direction, or control. Very strong language, and would think that would be recommended language to be in head coaches' contracts. Finally, if you look at this basketball coach's contract, unlike the football coaches, it says the head coach shall report to the athletic director. There's no confusion here. It's clear who the head coach is reporting to in this situation. Again, there are sample termination clauses that you'll find, and they're very similar in all of them, that the university may terminate the employment of the employee under this agreement prior to the expiration of the term for cause, and the cause shall include, in addition to any conduct, including acts or admissions, and admissions are important. Failure to act is not an excuse, of the employee in violation of any criminal statute, whether prosecuted or not, or any act of moral turpitude, any violation of any policy, law, regulation, constitutional provision, bylaw, or interpretation of the university, the NCAA, or the conference, and including any violation which occurred during or prior to his employment at the university. So, again, we go further on, and there's conduct for by assistant coach or staff members. All of those are acts that can get a head coach or an athletic director terminated if he's not having proper supervision of his staff and those people who work for him. And then finally, some really good language, I think, is that any failure or refusal to recognize or cooperate with the athletic director or other university officials, including any compliance personnel, is a reason for dismissal. So those are some really, I think, good language. There's some that I like better than the others. I hope I pointed those out to you. But removing ambiguity from your contracts is a good thing, not a bad thing.
Okay, so you have your structure in place, you have your compliance director, you reviewed all your contracts. What else do you need to do? Well, you want to establish a training program. And again, this is the type of thing that in the past, frankly, is often given short shrift and treated as something of a joke, if you will. You know, well, it's that time of year again, we got to go in and spend an hour, watching the videotape or listening to this person talk at us for an hour. The fact of the matter then, though, is that experience has showed us that a thorough, well-documented training program can have a dramatic impact both on the number of violations that actually occur and certainly on the perception of the compliance program. You know, it's funny. Something as simple as a sign-in sheet for training can be very powerful evidence, information, if you will, to show to a regulator, NCAA, government, whoever it might happen to be, about the steps that the university has been taking to try and create this culture of compliance that Bob referred to a little while ago. So what do you want to do? You want to have regularly scheduled training. This is not something where you sit around and you think, oh, you know what, it's been 10 months since we've done any training. I guess it's about time we should do something. The compliance director should have the authority to set up a regular schedule of training on relevant topics, keeping abreast of any changes, obviously, that occurs in the rules and regs that need to be disseminated. The compliance director should maintain copies of the training manuals. Again, some of this stuff might seem like, why even bother telling me this, but you'd be stunned at how often it occurs that a problem comes up. We'll go back in working with a client to try and put together a history of what the organization has been doing regarding compliance, and there's just huge gaps missing. They know they gave training on this particular topic, but nobody can find the training manual. Nobody can find the PowerPoint. So you need to keep a good archive of exactly what is the information that you're passing along to the student athletes, to the head coaches, et cetera. And as I said, maintain attendance records for training sessions. This is very powerful. You know, one of the things that occurs when you get an investigation from an outside authority, from a governmental authority, certainly from a prosecutor's office, that sort of thing, is they're going to be looking at, assuming there's a violation, well, who's responsible for this? Is this a loose cannon running around creating this violation, or is it really the university's fault itself? Simple documentation showing that, you know what, being able to walk into the prosecutor's office and saying, here are 3 attendance records, here are 3 sign-in sheets showing that this individual, we trained him on 3 different occasions regarding this very topic, and they still went out and did the wrong thing. That's very powerful. It's simple, but it's powerful evidence that can separate the entity itself from the individual who did the bad acts. The bottom line is you never want to be in a position where a violation has occurred and the violator can legitimately say, you know what, nobody ever told me I couldn't do that. You just don't want to be in that situation. Finally, and these are obviously we're keeping this within the time constraints that we have. These 5 steps are the minimum that you should be doing in setting up a proactive compliance program to protect yourself against bigger problems. But obviously, if a problem arises or if suspicion of a problem arises, you have to do a complete, objective, independent investigation. Well, what does that mean? What exactly are we talking about there? Well, you have to do complete information gathering. That doesn't mean you just go in and talk to 1 or 2 people and then you put a memo in the file and that's the end of it. That means that you have to get in there, get all the relevant documentation. Often this will involve doing an electronic search for emails. It's amazing what people say in emails, and emails are forever. So you get a lot of good information through the email system. And it's very important that no employee be off limits. That's up to including the head coach who's won the BCS for the last, 3 years running.
Excuse me. Most of the people that are listening to this and have heard you say nobody's off limits are saying he hasn't had to tell my head coach that he's got to spend 15 minutes, an hour and a half in an interview with the compliance director, or he has to sit in a training session. Good luck.
I understand that dynamic. The thing that you have to remember is this is not a new problem. This is not a unique problem to university athletics. Let me tell you something. I know there are head coaches out there that are nationally known, very powerful, very charismatic, big personalities. Imagine going to the main surgeon of a major hospital, the heart surgeon, who literally has people's lives in his hands every single day, and telling this heart surgeon, who's the main income generator for this hospital, he's the chief medical officer, that he's got to sit down for an interview about something that potentially took place under his watch. This is not a new phenomenon. And what I tell people is, blame it on the lawyers. You know what? We understand that the compliance director can be put in a difficult position there, where you've got a personality of that nature who needs to be questioned. Blame it on the lawyers. We're the ones who require that. And that has a tremendous impact. If you want to go to things in the news, I'll refer back to, I'm sure you all remember when Pat Fitzgerald was put in as special prosecutor when he was investigating the Scooter Libby thing.
That's Pat Fitzgerald, the lawyer, not the football coach.
Not the football coach. Patrick Fitzgerald, the then U.S. Attorney for the Northern District of Illinois. Fitzgerald interviewed the sitting President of the United States because it was necessary to do a complete internal investigation. The bottom line is, I understand it's difficult, but it's got to be done. And again, blame your lawyers. That's a tremendously easy thing to do, and it's helpful. If a violation is verified, obviously you have to appropriately punish the violators. Now, setting up a good compliance program doesn't mean that everything is treated as a capital crime. There are violations and there are violations. And so part of your compliance program is having an appropriate list of graduated penalties that are used in an appropriate manner. You obviously want to take steps to correct the holes in the system. If a violation occurred, something allowed it to occur. It might be minor, it might be major. But in any event, you want to take a look at it and see, is there a way that we can do this better? Is there a system, a check and balance we can put in that we didn't have before to avoid this happening again? And perhaps most difficult of all, once you're done with your investigation, once you've fixed the holes, once you've meted out the appropriate punishment, you have to voluntarily and forthrightly disclose the results to the appropriate authority if that's involved, be it the NCAA, be it whatever. This is often the hardest sell, frankly, that I have with clients in the compliance area. The answer is, or the question is, well, what do you mean you want me to go to the government and self-disclose that, we were overpaid $500,000 on a government contract? That's crazy. Why would I do that? And the answer is the difference in the ultimate result between what is going to happen to you. On the one hand, if you go forward and say, you know what, we have an active compliance program, government, NCAA, whatever it is, and because of our compliance program, we uncovered this problem, and we have taken the steps to correct it, and we've meted out the appropriate punishment, and we're here now to wrap this up and close this chapter, and what can we do to make this right? You will get one result in that type of approach. You will get a much different result if instead of you going to them, the government or the NCAA or whoever comes knocking on your door and says, we just found out about this violation, and by the way, we understand that you've known about this for 6 months. Why in the world are we now finding out about it through a third party? Why didn't you come to us? That's a much different and much more difficult dynamic. So it is a hard bandage to rip off sometimes, to admit that there's been a problem within your organization. But the long-term benefits of dealing with it in that manner are tremendous and should be done that way.
And it has been pointed out that in a lot of our discussions, we've focused on NCAA rules or conference rules or even university rules. But language should be included in the coaches' contracts, and some of the examples that we've had, it is complying with state and federal laws. Those are very, very important that you have to be in compliance with them. And also there could be legal requirements that requires you. If you look at the Penn State, there was a legal requirement that they reported those violations to state officials, and they didn't, and that's part of the problem that they had. So yes, we have focused mainly or a lot on complying with the NCAA rules and regulations and conference rules, but also you have to comply with state and federal laws. And that is another reason why dealing with the general counsel's office and having the compliance director dealing with the chief legal officer of the university is a good catch-all sort of protection that you could have. So let's kind of recap as we're coming towards the end and want to leave some time for some questions or comments. Where we are. So what we think is really important is that you set up a proper organizational structure, that you hire the right compliance director and provide that person with the necessary tools, that you review all your contracts to make sure that you have proper language in there, and again, going back to making sure that you have a proper not only compliance with your athletic rules, but also with state and federal rules. Going back to hiring the proper compliance director a little bit, it's also bringing in other people and allowing those people that have experience in dealing with compliance and athletics, a combination of those. There are those out there that can help you and provide those kind of services is really important. Establish a training program that is both specific and universal, that it applies both to athletics and to the university at large. And then you arrange for a complete, objective, and independent investigations when they are necessary. Certain things that should make you wince as you're kind of listening, if you hear this on your campus, when there's no mention in any of your materials or in the athletic or in your contracts or in your manuals that the primary goal is to provide a quality educational experience. If you hear that all representatives of the athletic program are responsible for being familiar with the regulations governing recruiting. If everyone is responsible, then no one is responsible. We want everybody to be a little bit more than familiar. We want them to know the rules. The excuses that you might hear, and I read this, and I was just reading the book, The System, that just came out, and they said when there was some mistreatment or some claims of mistreatment of a student athlete, they said he knew the sort of discipline and hard-nosed approach required to compete. It is, after all, football, not the glee club. If they're pushing their players to the brink, we wanted to compete with those teams. Our players had to be just as hard. Also in that same book, it said, the president of the university said, the AD is close to the coach, and I did not want to micromanage. So as the president, I kept my distance. As we look back at Section 2.21, that's not a defense. The president or the chancellor needs to know what's going on, and the fact that he kept his distance is not going to relieve his obligation. And then finally, also in that book, there's just some very interesting comments in there. They said, we can do our own review. There are all sorts of kinds of risks associated with having outsiders poking around the football program. It is impossible to predict what they might find and where those findings might head. Well, that's the risk, and not finding those things creates bigger problems down the road than finding them early and doing a proper review and having a proper compliance program in place. You'd see a lot of things that are written in contracts, and some of them are really good. Sometimes they can be stronger. Again, I can't overemphasize how important it is to understand that the student athlete is paramount, and the welfare of those student athletes and providing an educational opportunity for them it should be the #1 priority. A reporting procedure that includes senior level review outside of the athletic department, very important. Absolute autonomy for compliance. We think that's critical. Clear lines of reporting, who reports to who, and where those, make sure that there's some independence. Understanding that an outside review is not your enemy. And really important is that rules compliance meetings are not a punishment. They're important and necessary for you to have a proper compliance program. If you remember nothing else from this program, always remember that the cover-up is always worse than the crime. We learned that back in 1970s with Watergate, and it still holds true today. The most frequent question that's always asked, and I heard it today when I was listening to some of the hearings on the new Affordable Care Act, is who knew about it and when did they know? So that's a question that's always going to be asked. And then the ultimate question is, what did you do about it? But Jen, you had mentioned earlier something a little bit about attorney-client privilege. And if and someone asked that question, do you have attorney-client privilege if the general counsel is involved, or if the compliance director is a lawyer, or is that important?
It is important. It's a very good question. When the compliance director, assuming the compliance director is not an attorney, if the compliance director or people on the compliance director staff are, for example, conducting interviews, conducting an investigation, none of that is privileged. None of that is privileged. And what that means is the memos that they write up, the information they gather, their own observations, their own opinions. If litigation comes, if a subpoena comes from a governmental agency, anything like that, all of that is subject to disclosure. Your thoughts, the internal thoughts of the compliance department are going to be out there. On the other hand, if an attorney is doing it, if an attorney is running the investigation, be it in-house counsel or outside counsel, you do have attorney-client privilege. Now, it's attorney-client privilege that belongs to the university. So, for example, if you have an attorney sitting in on an interview of a potential violator, okay, an assistant coach, let's say, and they're interviewing that person, the attorney's notes in the memo, his or her impressions of the witness, all of that is going to be privileged and not subject to disclosure. But the other thing that you need to know is there's something called upjohn warnings. And again, you need, when you have people running these investigations, they need to understand all the implications. When you're interviewing somebody who's relatively high up in the organization, like a head coach, for example, or an athletic director or whatnot, they might think, well, this attorney, I'm talking to this attorney, it's the attorney for the university, and therefore this is a privileged conversation. Well, it is for the university, but it's not for that individual. And so there are things called upjohn warnings based on a Supreme Court, the Upjohn case, that need to be given at the beginning of the interview so that the person who's being interviewed understands, look, the university can keep this stuff confidential, but if the university decides it wants to turn over its findings of the internal investigation to whoever, it's allowed to do that and you can't protest. So that's kind of a long answer to what might seem a simple question, but the bottom line is is, especially once you get into a situation where you're investigating a potential, relatively large problem, you want to have a lawyer involved in all of the interviews so that you maintain the attorney-client privilege for the university.
Two other questions that were asked that I want to get to. One, the authors of the book, The System, were Jeff Benedict and Armin Katayan. And the other question was, it sounds like a great program. Sounds like setting up a compliance program is really important. Sounds like doing an outside audit of my program is a great idea. But I'm at a small school. How do I convince my president to spend the money? And I guess I would answer as kind of what we started off when we sort of looked at the expense at Penn State and the fact that they spent over $100 million on their problems. If you look at Rutgers, they had to pay off the basketball coach, the athletic director. The expense, it's sort of what is the old expression of penny now, pound foolish, or something like that. So you either can pay now or pay later, and a little preventive care is really critical. So I would go to my president or my chancellor or the person who's controlling the budget and saying, I'm spending a little bit now, but what this is going to do is take me out of the line of spending a lot later. So I think that would be kind of the argument that I would do.
We got one question or comment that came up, and I think it is important to note that you don't judge the effectiveness of a compliance officer based on the number of violations they find. This is not, they don't work on a commission, okay? Obviously, it's relatively rare in any organization of any size that over a period of time there are not going to be some violations, just inadvertent, innocent violations. But I agree with the comment that came up from one of our audience members here that the implication should not be that, well, if you don't find any violations, then the compliance officer must not be doing his or her job. That's not what we mean to be saying, obviously. And if that's the case, if the compliance officer goes through everything and things are smooth sailing and there are no problems, that's terrific. But you're not going to know if that's the case unless you have somebody in that position looking for it.
Another question, and we're about finished with our time. And again, if you have, we really thank you for your participation. That if you have additional questions that you want to ask us offline, both Jan and I's contact information is included on this slide right here, and we'd love to talk to you and see if we can help you either by answering a question or really looking at your program and giving you some good tips. There is an NCAA best practice guide, and I would suggest most of the compliance directors know how to get their hands on that. So yes, there is a best practice guide, and those things are should be used, and they're good for getting that culture of compliance. So that's very important. Someone asked, do law firms specialize in these type of audits? And the answer is yes, we do. We kind of come in and look at your program and sort of give you some advice and help you try to implement those kind of things. Again, if you have some interest, please contact us. We'll be happy to do that. So again, thank you very much for attendance, and hope we provided some useful information to you.